So estate planning and probate, the laws are the same throughout the state of California, but the procedures are different, and more importantly, the attorneys can vary. Really excited to have here a woman that I saw on a podcast do a great job on estate planning, but also does trust administration and probate administration, Somita Basu of the law firm Norton Basu LLP. Somita, thank you so much for joining us today.
Thank you for having me.
Wow. So you're based in Northern California?
Yes, our main office is in Northern California, but we have offices in Oakland, Santa Clara, Los Gatos in the Bay Area, and then we also have an office in Los Angeles for our Southern California clients.
And then your particular practice, personally, you are primarily involved in trust administration and probate administration?
Yes, I handle most of the trust administration and probate administration for our firm, and some litigation cases as well.
And I think you mentioned you handle litigation for the clients that you take. You're not necessarily looking for litigation specifically.
Litigation is becoming a bigger part of our practice. We're finding that there is an increased desire to fight over money. I don't know if it's economic pressure or, something shifted during the pandemic and after. And so we are finding that even though the amounts in controversy might be less than what would be ideal, people are willing to still pay attorneys' fees to fight over it.
Wow, that's interesting. So, and are you more commonly on the defense on the litigation side of the
it can be, it's both. It's equal between both.
So let's talk about that then, because I get probably a lot of people call me and say, so-and-so's cheating me, what I do? And I try to walk them through what the costs are of litigation. It's obviously very expensive, and there has to be a certain amount of money at the end to make it make sense. How do you advise customers that come to you, they're upset, they feel cheated, but there's got to be enough money to make sense in this. Otherwise, they're just punishing each other financially, right?
Yeah, I mean, litigation is always a lose-lose proposition, right? I think all, the big litigators that you've ever heard of would tell you that. Nobody comes out a winner in the vast majority of cases. Litigation involves not just a tremendous expense financially, but it takes a tremendous toll emotionally. And you have to be willing to put up with that and endure that for a very long period of time, because as you know, our court system is not very efficient. And so cases drag on for years. And so if you're not willing to be invested emotionally and financially for that period of time, then it's probably not worth it for you to litigate. And that's something that we advise our clients on, very frankly.
It's almost like a part-time job, right? I mean, you have to be available for depositions and for paperwork and for hearings, and though maybe you can come in online today in a way you couldn't before, but still, it's a lot of work to be involved in litigation.
It is. It's a lot of work. It's a lot of time for the people who are involved, and it's very, very expensive.
Mm-hmm. So when somebody comes to you, do you give them advice of a ballpark of what it takes or what it costs or what the percentage is or what kind of...
We definitely like to give clients a heads up on how long we think the process might take, how much it might cost. We definitely try to be very upfront with our clients. Our approach to the practice of law is very, very practical, because at the end of the day, there are a lot of things that might be legally possible, but the things that are practical and the things that are good for our client might not be a complete overlap of the two Venn diagram circles between what's good for the client and what's legally possible. A lot of things are legally possible. The question is, do you have the time, energy, effort, and money to make it happen? And for most people, for the average person, even in California, it's really not something that, they want to spend 5 years and $200,000 litigating.
And typically that money has to come up front unless there's enough in the estate and likely enough that you're going to win that you would take on a contingency. So typically, is it all in advance, or is it pay as you go, or is it?
It's pay. We ask for a retainer up front, and then as the retainer gets drawn down, we will ask for additional money to replenish the retainer. There are some attorneys who work on contingency, and sometimes when clients can't afford to pay any retainer, we will refer out to attorneys who will work on contingency.
But that's a big chunk, and if it's not contingency, you're paying up front, like you say, to get to hearings, by the time you're with all the discovery and all the procedures and delays, it can be years. And I tell people as a general experience, it's a couple $100,000.
Yeah, it's not an inexpensive proposition.
Yeah. So let's talk about what causes people to be vulnerable to being sued. I'm sure that part of your litigation, part of your legal work are beneficiaries who feel they've been taken advantage of and want to sue the administrator, but I'm sure some of it is the administrator defending themselves because they did the things the best they could and they can't go back and solve hard feelings of a lifetime of being raised together. What are some of the most common mistakes that administrators or executors in probate or trusts make that leave them vulnerable or costly litigation targets?
Yeah, so I think one of the things to keep in mind is communication is key, right?
Mm,
And you have to communicate whether you're the administrator of a probate estate or the trustee, you're doing trust administration, you need to communicate with the beneficiaries. And that is your role as the administrator or the trustee, is to communicate with the beneficiaries. Legally, your attorney will tell you what needs to be done, but the communication with the beneficiaries or the heirs, that is something that the administrator or trustee needs to take control of. The more communication there is, the smoother the process will be. And, you're right, though. A lot of times, even if the administrator or trustee has done nothing wrong, there will be a sibling or a relative or another heir or beneficiary who will file something against you as the administrator or the trustee because they're basically trying to litigate their feelings. And that's never a good place to be. So that happens quite a bit.
it happens quite a bit, and I see it happening, and I often feel like, it um, it's just so painful to watch. And I always advise as a real estate agent, disclose everything you can as often as you can. You can't really, document too much. That's how we are as real estate agents as well, is you really can't document too much. Administrators are sometimes hesitant to share information. Is that the most common breakdown, just not sharing what's going on and not
Yeah,
responding?
it's usually, not being upfront, not discussing what's happening in the case, not sharing updates with the other beneficiaries. Those usually are what lead to the most problems. Sometimes, however, no matter what you do, your brother or sister or whatever is going to have hurt feelings. I mean, it stems from childhood, or mom said did this with you and not with me, or I took care of mom in her last days, so I should get more. But unfortunately, that's not how the law works. So unless mom wrote that down, you're getting the same as your other siblings who didn't do anything to take care of mom. And so there's always hurt feelings and resentment.
Right. Yeah, and I think that bad relationships don't get better when money is in the middle of the pot to fight
Yeah,
over it.
exactly.
It seems like it's exact opposite.
Exactly.
So I know that as a firm, you guys do estate planning as well, and I know that must mean that you talk to people, some of which do follow through and implement, others that you have the intake with and never finish it, or they never end up funding the estate plan. What do you see as the common thread for people who start that process and finish it and get the benefit of the work they put into it?
Yeah, I think the best thing about an estate plan is peace of mind, right? So people think about their estate plan, oh, I'm going into the hospital, or I'm about to go on a trip and leave my kids for, a month. That's really not the time to do it. You want to do it when things are calm, when you have the ability to think through all the different scenarios of what you want, especially if your kids are minors. And I think too many people, if you haven't done it, if you started it and you haven't finished, you're not protected. Your family's not protected.
Right.
We have had situations where spouses were denied access to, the other spouse's medical information,
Right.
and they didn't have their estate plan updated, etc. And if you were in a different jurisdiction, they don't automatically share information with you as the spouse. But if you have the proper documentation in place, then they will likely honor it. So, these kinds of challenges can come up, but if you're in the middle of a crisis, it's too late. And I think that's the peace of mind that people who actually get their estate plan done, they have that peace of mind. It's always okay to change it later.
Right.
It's never going to be 100% perfect.
Right.
But you do the best that you can with what you know at that time, the way your family is, your family situation at that point in time, and then it evolves with you as your life and your family evolves.
Well, and I'm sure you see this too. I see so much litigation where a estate plan was started, right? They never, there's no signed copy. Was there a signed copy ever? Or they finished it, but they never funded the trust, or they made some changes but never finalized the process. And it just seems like if you just take the extra effort and finish the job, do it to completion, get back the book from the attorney or however that gets done at the end, then you have the peace of mind of completion and knowing whatever comes up. So do you ever get in a position where you have to kind of encourage your customers or clients to finish the process? It seems to me, you're the attorney, your job is to give them the legal advice, but somewhere, maybe because I'm a real estate agent, we're more involved in kind of motivating people to buy a house, motivating people to save money, motivating them to get an estate plan and finish the job. Is that part of the job, or do you see that part missing, or how do you address customers that do half the work and don't finish it?
Yeah, so we do a lot of following up, but we will not do that indefinitely. It doesn't make sense for us to do that indefinitely because
Right.
we're not your parents.
Right.
We are your attorneys.
Right.
You're paying us for a service. We've provided a service. We've given you a draft. We're waiting for your feedback. If it's been 6, 7 months from the time you started the process and you still haven't finished it, after that amount of time, we will stop following with those
Right.
clients. Because at some point, the client has to want to get it done, right? I can't force a client to get it done. And we don't want them to come in and sign any document they haven't thoroughly had the chance to review and ask questions about. So at that point, once we've done the majority of our work and gotten a draft to the client, it's really the client's homework to do. And there's only so much we can do. So we try our hardest to get the clients over the line, but some clients just can't get there. And that's just a decision that they've made.
There's a piece of ancient Jewish wisdom that says, more than the calf wants the milk, the mother wants to give the milk to the calf. And I think in coaching and in professional services, sometimes we want for our customers sometimes more than they want it, and we have to draw a line somewhere, right? And
Yeah.
as a real estate agent, I want them to get the estate plan. I don't get any more commission. I don't get any more money. But what I do get is a customer who doesn't call me, his kid, 5 years later, dad died and we have to go to probate. Can you help me? I can help with that, but that's not really what I want to see happen. I want that family taken care of. And so it's important. And I would say, Samita, the reason I do these calls is to offer as a real estate agent to customers, look, at the end of the day, if you have real estate, you want it, when you're done with the trust or the estate plan, typically real estate's deeded in a trust. As a real estate agent, I can get that final deed once it's been recorded, and then there's a delay in the county document system, but I can get that final copy confirmed, put in the book to finish the job. The job's not done until the final paperwork.
Yeah.
And use us as some of that follow-up. So that's the role that I try to play with customers, is say, let me help push a little bit. You have to want it, but that's kind of the job along the way. So we want people to get the job done, I think. So let's talk about probate administration, because that's a different case, right? Now, for whatever reason, we don't have an estate plan in place. We didn't plan ahead. We have to go to the court. We have to use their process. And somebody has to file to be the petitioner, and somebody has to take the role of administering or executing the will, if there's one, through the probate process. What's the role that you play in that? And where do you see clients who need extra help? Where do you fill that role?
Yeah, so for us, when we sign a probate client, we like to say we're the quarterback of the team. So we're calling the plays. We are, telling or calling an audible, depending on, what's happening and what we're seeing, but we are driving the process. We don't expect our clients to know how the process works. We don't expect them to show up in court. None of those things. They're obviously welcome to if they'd like to. I've never had a client show up to a probate hearing. I've done all of them on the behalf of our clients. It goes pretty smoothly. We have quite a bit of experience in all the major California, Northern and Southern California counties. Inland Empire, not so much, but we've done a few there as well. But yeah, so we kind of know what the judges like to see. We know what are the unique little idiosyncrasies of the process of each county, and it's very different. It can be very, very different. So we've kind of managed to compile all of that knowledge over a decade of doing this so that the process goes much more smoothly for our clients. And so we're holding their hand through the whole thing. We're telling them exactly what's the next step. This is why the court is asking for this. This is what we need from you. This is how the process works. So we do all of that for our clients on the probate side.
In every business, there's a continuum of service and price, and along the way, there's, you pay for more, you get more, you pay less, you often get less. How do you describe where you fit on that continuum for your clients as far as what it costs, and then also what you provide for them as far as service?
So probate is a statutory fee. So the fee is calculated based on the value of the assets. So there isn't any wiggle room there. We like to think that we go above and beyond in terms of communication and kind of driving the process forward, trying not to let it lag. I've seen probate cases lag for months and years because the attorney didn't just do what they needed to do. We try not to let that happen. We also, on the advice and counsel side, when we do things hourly and we are advising, a trust beneficiary or a trustee, we feel that we provide constant, regular communication in a way that our clients can understand. We are not the attorneys that you're going to have to call for 3 weeks and never get a hold of. That's not how we practice. We pride ourselves on very high touch, white glove service for our clients. And so the clients who appreciate that are the clients who we really like to serve.
Okay, so you're handling for the client the work. I do know there are discount services, but then the customer has to do the heavy lifting. And my experience is they don't know what they're doing, so they're stuck in the mud. I come across these all the time. Well, I found this person, they're a paralegal, or I found this attorney through a friend, and he really does, DWIs, but he's going to do the probate for us at a discount, but doesn't really know what he's doing. And having been in probate court, pre-COVID, I was there every day. You saw so many attorneys who had no idea what they're doing, and yet you saw the experts. It was like boom, 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 boom. Like the difference was obvious between those who know what they're doing and those that don't. So I can say that because I'm not an attorney. I'm not bad-mouthing my colleagues. How do you describe the difference when customers approach you? I'm sure almost every customer at some point must say to you, "Oh, well, this guy promised to do it for less." How do you answer that?
Well, we say that this is all we do. We don't do a whole bunch of other little things on the side. Our entire focus is estate planning, probate, and everything that's related. We don't do, family law. We don't do restraining orders. We don't do criminal law. We don't do bankruptcy. We do this area of law, and we have been absolutely dedicated to enhancing our knowledge and improving our practice in this area of law. And I think it shows in the way that we represent our clients. And the question is, are you looking for really good legal advice, or are you looking to save money? Because if you're looking to save money, we are not the firm for you. So then maybe you should go to somebody who has less experience and is willing to do it for cheaper. But we have learned the hard way not to compromise on our value. And if the client doesn't see that value, then we're not a good fit for each other, because not all money is good money.
I think you said in the beginning, and I'd done this research before I talked to you and set the appointment up, which was that this is all you do. And I think you do only this in the related pieces. And I think where customers don't understand is they go to a website, they can't tell what's related or not. As an expert in this area, I can. I went to your website and I noticed that you have practice areas: estate planning, which is avoiding probate; mediation, obviously between families, so probate; trust administration, hopefully you're avoiding probate; trust estate litigation, inevitably things go sideways. All these are somewhat related. Guardianships and conservatorships are related to entities that can't make their own decisions and basically are handled in probate court. So I think that's the important distinction. I always tell customers, when I get a customer calling me with an attorney that they've chosen, I go on a website and I see DWI and I see divorce probably could be somewhat related, maybe criminal. Oof, I know that's a problem right away. So you are an expert in this area. I did, ask you offline. You are here in Southern California from time to time, so you are able to handle trusts and estates that have properties or issues in multiple counties. And I think that was my interest in reaching out to you today. Was I know a lot of LA attorneys that are often looking for an attorney in Northern California to work with and coordinate a case. How much, if any, of your business is working with other attorneys on different jurisdictions, whether it be different states or different parts of California?
In general, we've done that a few times. We've had some, we've had to be, local counsel for out-of-state attorneys a couple of times. I've worked with some attorneys in the state of Washington. They've reached out to me, or fiduciaries who've said, I'm a Washington fiduciary, but the case is in California. I need an attorney. So we've done that. When there are cases that we think would be better handled by a local attorney in a different jurisdiction, and that is particularly true in some of the smaller counties, we will refer that out. It doesn't make sense for the client to pay 2 attorneys, and some of the smaller jurisdictions are very insular and have a very small group of attorneys and one judge who knows everybody, and they have dinner at each other's houses, and me coming in there is not really going to help the client at all. So we try to just refer those out. We don't try to hang on to those types of cases. We want what's best for the client.
But bigger states, businesses with property in multiple counties, LA, San Francisco, Santa
We can
Clara.
handle multiple counties within California without a problem, especially if it's, any of the major Bay Area counties, Los Angeles County. We don't have a problem with any of those. We can help with deeds. We can help with whatever. We have real estate, realtor referrals in all those counties. We have mortgage broker referrals in all those counties for the clients that need it. Estate clearing services, all of that kind of stuff. So if the clients need a referral, we have a good network that we can refer out.
Fantastic. And Somita is available. The law firm is Norton Basu LLP, and the website is nortonbasu.com. I'll have the link in the show notes in the description down below. Somita, thank you so much for your time today. I really appreciate meeting with you and sharing with our audience your practice, your services, and hopefully they'll get a chance to work with you.
Thank you so much for having me.